welcome back to another episode of The Socially Distant Lawyer. I'm Mitch Hayes.
And I'm Greg Vinogradsky.
On today's episode, we have a hot off the press issue, the Florida tort reform legislation, which is going to dramatically change Florida law as we know it, and is going to affect all phases of litigation, both plaintiff side and defense side. And we have our partner, Gabe Costa, from our Florida office to give you a local flavor as to what this bill means and some big takeaways. Gabe, why don't you tell us what's going on?
Thank you, Mitch and Greg. It's great to be on The Socially Distant Lawyer and to be given the opportunity to speak about this pivotal new law in Florida. New law is a comprehensive tort reform package that is very favorable to liability insurance carriers and self-insured corporations. It has been extremely controversial since it was introduced in mid-February, drawing a strong opposition from plaintiffs' lawyers and medical providers that treat personal injury plaintiffs under letters of protection. The bill was overwhelmingly supported, however, in the state legislature and went from committee to committee to vote, and ultimately last Friday to the governor's desk, where it was signed into law immediately. There's several notable changes in the law, which will make for a good discussion on our upcoming podcast. Here are some of the highlights, though. First, Florida is no longer a pure comparative negligence jurisdiction. It's now a modified comparative negligence jurisdiction. If the jury finds a plaintiff over 50% negligent, then the plaintiff cannot recover. This will likely deter that subsection of cases that involve high damages but low liability. Second, the statute of limitations for general negligence has been cut from 4 years to 2 years. Third is a significant evidentiary change and a significant constraint upon those cases involving treatment rendered under a letter of protection. Letters of protection have gained notoriety over the years for being a conduit to claiming inflated medical expenses and have led to disproportionate jury verdicts. The changes remove the letter of protection as a damages aggravator, essentially. Previously, a plaintiff could board the full amount of their medical bills at trial. The only exception was Medicare and Medicaid, in which case plaintiffs could only board the amounts Medicare or Medicaid actually paid. Also, that was only for past medical specials. Now, for past medical specials, the plaintiff can only board the amount of the bills that have been satisfied or are outstanding. This is regardless of whether Medicare or Medicaid are involved. The law also has specified methods for calculating the value of the plaintiff's treatment when treatment is obtained under a letter of protection. And the method for calculating it is tied to a percentage of the Medicare reimbursement rate or the applicable state Medicaid rate. For future medical expenses, the usual and customary amount awarded to uninsured plaintiffs is calculated similarly based on Medicare and Medicaid rates. And on the subject of letters of protection, it is now statutory law that they must be disclosed, as must be any referral relationship between the medical provider and the plaintiff's attorney, recognizing that this is relevant to the issue of the bias of the medical provider who testifies in most cases. Fourth are major changes to Florida's bad faith law. To begin with, the law changes the standard of the conduct the jury deciding bad faith can consider. Now, all parties, including the claimant and her attorneys, have a duty to act in good faith in providing information and making demands and engaging in the settlement process. Also, mere negligence will not support an action for bad faith against an insurer. Fifth, there is now a statutory presumption against liability and in favor of a landlord or property owner from a negligent security action if it can be shown that the landlord or property owner substantially complied with certain criteria set forth in the statute that concern minimum safety and security standards. Also, the trier of fact is now required to consider the fault of all persons who contributed to the injury or death of the claimant in the negligent security case, including the criminal actor. Lastly, the new law changes the plaintiff's attorney's ability to obtain a contingency fee multiplier. It creates a strong presumption that the lodestar fee is sufficient and reasonable, leaving a limited exception for cases where it can be shown by evidence that competent counsel could otherwise not have been retained by the plaintiff. There are several other changes, and we can discuss those further at our upcoming podcast discussion, which should be very interesting. But the changes are likely to reduce the insurer's risks of excessive payouts and nuclear verdicts, which have trended significantly higher and more frequent in recent years. The legislature and Governor DeSantis introduced a bill to curb increasing insurance premiums over the demand of many Floridians. Whether these changes have any effect will take years to see. But we can expect in the short and medium term is for plaintiffs' attorneys to find different approaches to maximize their damage claims for their clients. Now that there have been significant limits placed on the ability to claim past and future medical expenses. Likely, those tactics will include more of a focus on non-economic damages, such as pain and suffering, mental anguish, and loss of enjoyment of life. I look forward to our further discussion, Mitch and Greg, and thank you for the opportunity to contribute to the Socially Distant Lawyer this week.
Thanks, Gabe, for all that helpful insight. We're going to have you back for another podcast to discuss this in more detail. Thanks for everyone for tuning in for another episode of the Socially Distant Lawyer, and we'll see you all next time, and check out our social media platforms. Thank you.